Let's unpack today's court decision with attorney Tyrone Maseko, who joins us now virtually. Tyrone, thank you very much for your time. Just firstly, with regards to the judgment from today, does it have any legal implications on the judgment that we expect on the Ramaphosa application to have the private prosecution application by the former president struck down or struck off the roll in the High Court in Joburg? Does it have any legal bearings on that one at all?
Good afternoon, Maseko, and to your viewers. So I guess one can answer it in two ways, the question. So does it have, so remember that the High Court in Pietermaritzburg and the High Court here in Johannesburg are on an even keel, so they're on par. So the one's decisions don't really have to take into consideration the decisions of the other. Each of the courts will have to make a decision on the facts that have been argued before it. However, also, they're not binding on each other, let me put it that way. But the matters are so similar and the arguments so similar, the difference really being that the other one really relates to the president and what is said to be his complicity in the charges in the private prosecution, or the facts that belie the private prosecution. So in fact, in reality, it does. I mean, the court might not really have, well, I guess it can, because it's a judgment. It can have regard to it, even though it's a judgment that's now been given, it's interposed. So it comes between the arguments made by Downer and Zuma in the High Court. Will they really have regard to it? I don't think they have to. They can have regard to it. I do suspect, though, that the judgment should be along the same lines, purely because the facts they mirror each other. They really are the same. It's just different parties. So my suspicion is that for consistency, one might find that the judgments are very similar.
So the legal team and the Jacob Zuma Foundation has told my colleague Lethiwe Mdluli that the former president would appeal today's judgment. But in the judgment, Judge Paul Wallace and the full bench said that the respondent is interdicted and restrained from reinstituting, proceeding with, or from taking any further steps pursuant to the private prosecution. So if he does go ahead and appeal today's judgment, what is he able to do against the two applicants from today's judgment in particular?
Okay, so just to clarify, the judgment relates to the private prosecution.
Yeah.
And it has put a stop to further actions being taken by the private prosecutor, Jacob Zuma, in the private prosecution relating to Billy Downer and Karyn Maughan. And so they're not going to be steps taken in that regard. Now, when Dalimbofu and the like say, well, we're going to appeal that, what they then would seek to do is to deal with the judgment insofar as it relates to these orders. This does not affect anything else outside of that. Now, the difficulty and the challenge that they face is that they have to find grounds to appeal. It's all well and good an hour before judgment has been delivered to say that I'm going to appeal. First, you have to obtain the leave to appeal the matter from the court that made the judgment. I think it's about 60 to 70 odd pages, this judgment. There's just no way that you can find grounds to appeal in such a short space of time. And that to me suggests that these matters are not being conducted purely on merit, but rather, and this is what the judgment deals with as a matter of interest, but really as a strategy, as a stratagem to deal with the main case, which is the corruption matter, the arms deal matter, to stay there, to ensure that that does not proceed. And so for as long as you have these interim processes and this litigation going on, they're unable to continue with the main case. Now, to suggest that I want to appeal a decision before you've even satisfied yourself that you've got grounds to appeal, I mean, it's not a right that, you can be heard on appeal. You have to convince the court that you've got a case which is appealable. And so, it suggests that this actually supports the decisions by this court, that actually what we're dealing with here is Stalingrad tactics, even though they don't really put it in those words, but it was argued in that vein. And it's unfortunate. It's difficult to say. I mean, we can chat about whether they've got grounds or not, and we'll see when they eventually bring the notice to appeal on what grounds they want to appeal the matter.
As an attorney, what do you think, though, Tyrone, looking at the fact that they're saying they're going to apply for leave to appeal the actual judgment that is stopping them from pursuing Karyn Maughan and Billy Downer on a private front. What would you say? Do they have grounds? Actually, do they have a way of arguing that they be heard on appeal? Especially looking at what the judgment said about him trying to evade the actual case that is supposed to continue in August, the corruption case.
Yeah, I mean, the latter point being a point that they don't admit, in none of the cases that we've seen so far has Jacob Zuma's legal team or Jacob Zuma himself considered that they actually engage in Stalingrad tactics. So they're not going to admit that, fair enough, and it's not for them to make the point and accept the point, fine, fair. But and really to get to this conclusion of Stalingrad, you really have to look at the tactics. I mean, what we're dealing with, and it's so easy to forget that essentially this matter, and the judgment raises that this is really the fourth attempt at getting Billy Downer off the case. You'll recall that initially this was argued before Judge Kuhn. They attempted to appeal it in the Supreme Court of Appeals, was dismissed, and tried to take it to the Constitutional Court. That failed, and so this is another attempt. This is now failing. So what we had is just repeat attempts to try to delay that and to get Billy Downer off. But to answer your question directly, it's still early days for one to make a conclusion as to whether, as a matter of law, yes, they can try to appeal. That's a right they have to at least to bring the notice to appeal and be heard. Not sure that to be heard is necessarily a right they have. I don't think so. The court can refuse to grant them leave to appeal. And it's not for me to say at this point what it is in the judgment that they would want to attack. I mean, that would be prejudging the matter. I've got no idea. It's a long judgment. And the judgment itself deals with a lot of aspects. I mean, it's not as if the court had to answer one question. There were at least two or three, well, I read 3 arguments that were made and that the judgment centers on. So in there, you can pick any one of them and say that the court misdirected itself here, did not consider these facts here, did not consider that. But ultimately, what really weighs against them is that you have a number of judgments now in which Jacob Zuma actually fails to make this case. So this, in essence, this issue has been looked at a number of times and it has been dismissed a number of times. So these are grounds that have been looked at by the judges. And when I say judges, I mean the High Court, Supreme Court of Appeal, and the Constitutional Court. So to keep bringing these arguments, the same argument in a different guise, is unhelpful. And so that's why personally, even before seeing what the grounds would be for appeal, I already think that they're unlikely to succeed purely on the basis that all these arguments have already been considered by the higher courts.
Looking at the language that was used by the bench of judges when they actually delivered this judgment today, I wonder what you think in terms of the legal team of Jacob Zuma, obviously led by Advocate Dali Mpofu. Some experts and even News 24 felt that the judgment was basically saying there were blanket denials by his legal team and that he was let down by his legal team and how it advised him if it agreed on his, on what he actually instructed them to do, especially pertaining to what you just alluded to with cases regarding his medical records being struck off the roll at the Supreme Court of Appeal, being struck off the roll in the Constitutional Court. Do you agree with people who say that his legal team actually had advised him incorrectly?
Again, I mean, it really isn't for me to say. We can all give different advice to clients, and no, you can never get 2 lawyers that agree on any facts. But the big concern, I guess, is that ultimately, and this is a difficult position that they faced. I'm in pain to say that, I feel for them, I don't. But the difficult position that they faced with what they were trying to advance in this case is that what they sought to do ultimately in the private prosecution is to say, look, all these arguments, all of these things, don't worry about it. Just allow us, in fact, allow the respondents, or in this case, the applicants, Karyn Maughan and Billy Downer, all these things that they want to say, they should say all of this, they should plead all of this in the criminal case. And the converse of this, the other person saying, no, the criminal case should not even happen. This private prosecution should not even happen at all. There are no grounds for it. And so it would have been difficult for Mpofu and co. to to really go down and dispute a whole lot of the allegations that are made by Downer and the like about the animosity that Zuma has against them, you know, all this argument of abuse of process. It was difficult for them to really delve into it. In fact, they specifically did not want the court to go into the arena because they said that should be remitted and be left to the domain of the criminal court to deal with. And there arose a dispute. And so, you know, when you consider it that way, the parties were so opposed to each other and so far from each other that ultimately they could not have challenged any of those facts. And they proved to be the detriment or part of it anyway. I mean, I thought the reasoning of the court went beyond it. The court could have actually dismissed this case without having to delve into a lot of that, the abuse and the like. They could have dismissed this on technical grounds relating to the summons itself and having set aside the summons because of things that are just not curable in the summons. For example, the summons against Karyn Maughan should not have been issued because the nolle prosecute did not relate to Karyn Maughan, and on it goes. And by the way, that is going to prove, I think, to be an essential ground in the High Court in Johannesburg against the state president.
All right. Does this also just raise a debate that needs to be had, perhaps, in terms of the Criminal Procedure Act and nolle prosecute certificates, private prosecution, and whether or not, you know, whether it's a high-profile politician or just a very wealthy South African can abuse this part of the act?
I don't think so, actually. You know, if one reads the judgment and if one reads the Criminal Procedure Act, it's actually not that complicated. I mean, it's been made to look complicated now, but I thought the judgment was actually useful in this point because what it also deals with, besides the raft of requirements that one has to meet, a private prosecutor has to meet before they can bring a private prosecution. But one of the essential ones that you actually have to have a substantial interest in the matter. And Jacob Zuma was found not to have one, and I'm not going to go into the details right now. One can read the judgment for themselves. It is quite lengthy and an intricate argument. But there is an important requirement because what it does is to prevent this prosecution, this abuse of private prosecutions by individuals. Fortunately, we haven't really seen a lot of that in South Africa because unless you're able to show that actually you've suffered some injury or harm by another party and the state is now refusing to prosecute that party, it's an important requirement. Unless you're able to show that, you're not entitled to privately prosecute another. So I think it's purely a question of ensuring, and that's what we've seen here, ensuring that the law actually take its course. Unfortunately, I mean, these processes cost a lot of money. It would be difficult for a private individual who's now being privately prosecuted to launch a similar application to set the summonses aside. Unfortunately, we don't see a lot of it purely because the state, in most cases, if there are grounds to prosecute a matter, will prosecute a matter. And we hope that, you know, it stays that way, and then we'll prevent or just close the loop of the possibility of private prosecutions which are unwarranted and are purely an abuse of process. But there are learnings, I think, for the NPA and all of us.
All right. Tyrone Maseko, legal expert, thank you very much for your time.